Hi, I'm Anna Denton-Jones of Refreshing Law, and I normally shy away at Christmas from the usual solicitor's scary email or mailer warning everybody about vicarious liability and liability for harassment that goes on at Christmas parties, because I think it's all a bit bar humbug. But actually, this recent case that I'm going to talk about is quite interesting and talks about what the boundaries of that might be. I thought you might be interested. So there was a Christmas party that was organised by a small business owner where he invited his staff and their partners. And there was the official sort of work-related, if you like, event. And at the end of that, taxis were paid for to the hotel where a number of people were staying. And they decided to stay up in the bar drinking. Now, much of the conversation at this stage of the night is just social. But about 3 o'clock in the morning, things deteriorated. Everybody's presumably a bit worse for wear by this point, and the sales manager decides to challenge the business owner about a decision that he'd made recently in relation to recruitment. The business owner takes umbrage at this and views this very much as challenging his authority, and starts with editing out of all the expletives to say, it's my business, I make the decisions, in a nutshell. However, things get even worse. He strikes the sales manager twice, presumably punching him, and he falls to the ground and is knocked unconscious because he cracks his head on a marble floor. For the witnesses, I think it was quite frightening. One of them reported thinking the guy was dead. Somebody else noted there was blood coming from the guy's ears. Unfortunately, he's been left unable to work. His brain injury was so severe, he still has problems with his speech, with mood and fatigue, and verbal reasoning and things like that. So he's probably not going to work again. So he was suing for the personal injury suffered, and was trying to make the company vicariously liable for the actions of the owner. So the judge had to decide in the High Court to what extent this was a work-related, was this connection with the workplace in order to make the company liable. And presumably the judge has got in the back of his mind the fact that you don't want to open the floodgates and any old situation suddenly become one where an employer could be responsible. And for that reason, he actually decides that no, this is not work-related. This is an impromptu extension of what was an official work event earlier in the evening and shouldn't be deemed to be connected with it. Now, I presume that different judges might, on a different day, decide differently on this. It's one of those very finely balanced things, and I think if you asked a room full of 10 lawyers, you might get 10 different opinions. But it does show that there has to be a point at which a company can't be responsible any longer for what is going on. So worth bearing that in mind and contrasting it perhaps to some of the other cases that we've had in relation to vicarious liability. So I'm thinking of the case last year where somebody worked in a garage forecourt, got out of his little booth and went and stabbed somebody who was filling up with petrol. Obviously the employer was found to be liable then. There have been cases in the past of nightclub bouncers stabbing clubbers, and again the employer being responsible. Both of those cases, those people were at work when the incident had occurred. This case obviously contrast, they are outside of work and quite a number of hours outside of work, and the connection with that official work event was deemed to have been broken. So it'll be interesting to see how the law develops in this area. Merry Christmas and have a Happy New Year to everybody, and I'll be back in the new year. If anyone's got any questions, adenton@refreshinglawltd.co.uk.